Very good evening to everyone. Thanks for joining us this month. This month, we not only have our regular monthly update, but we also have the conversations with IR gurus. So the monthly presentation will be really brief. We'll cut it down in less than 10 minutes, I guess. To start with, the government of Tamil Nadu has circulated its code on wages rules. Nothing significant, no changes, significant changes in it, except the dearness allowance part, which at the moment the government revises only once a year. They have now planned to do it twice in a year. There are a few circulars that have come about. Andhra Pradesh government, following a judgment of the High Court, has issued with regard to women employment in night shift, which at the moment is restricted there. Though the Madras High Court has already struck down the provision and said that women can be employed even in night shift, many states have not been following it. The government of Andhra Pradesh has now issued a circular in this regard, saying that with the consent of women, they can be asked to work in night shift in factories. The Telangana government also in the same line has been not only the factories, but also in other establishments under the shops and establishments. Also, they can employ women in night shifts, provided there is a consent and transportation facilities and safety measures are taken in this regard. The ESA Corporation has issued a circular saying that they have come to know that in many cases, the same bank account number has been tagged for many employees. So instead of actually tagging the employee's bank account, some different account or just one account of one employee is being tagged to many, and they have asked employers to ensure that it's the correct bank account of the employee is tagged and one bank account is not tagged to many employees. The Provident Fund Department on the EDLI scheme has said that the benefits should be passed on within 7 days on this, and to whom they are eligible has been once again clarified by the Provident Fund Department in its circular. Moving on to the quiz segment for this month. According to the Occupational Safety, Health and Working Conditions Code 2020, the employment of audiovisual workers shall be prohibited. That's where you need to prohibit it without what? Should it have a monetary benefit or a traveling allowance or agreement or accommodation? We shall see the answer at the fag end. Going across the globe, in Canada, they have introduced a medical leave of up to 10 days in a year, depending on the length of service. It's a proposal that has been there. And they also introduced what's called as a bereavement leave in the event of death of a child or stillbirth. In both accounts, they have up to 8 weeks to 12 weeks of leave can be availed. But the leave is not a paid leave. Whereas in India, if you look at maternity benefit, it's a paid leave. But Canada is only now introducing a bereavement leave, and even that doesn't provide for a paid leave. Czech Republic and Slovakia again have introduced paternity leave. It's more to be in consonance with the EU regulations of up to 28 weeks from the date of child's birth. And if it's in the case of a twin or more children, it could go even up to 37 weeks. And Slovakia also provides in the new amendment that if an employee is to work in an outside country, the contract should specifically state the place and the period and time frame within which the employee will be working abroad. In UAE, there have been certain amendments, and these amendments again is trying to attract and enhance the UAE's competitiveness in the market and requires every contract to have a specified period. And of course, it could provide for renewal of the period of employment. So that tells you whether it's a full-time employment, how flexible or part-time employment. The employment contract should have all these specific clauses in them is what the new regulating law provides for. In the knowledge corner this month, we are going to look into the Supreme Court on minimum wages. One of the earliest cases of the Supreme Court where they came about heavily on employers is saying that if you don't have the financial capacity to even pay minimum wages, you don't need to, your existence is not justified. You can just practically, an employer who's not in a position to pay minimum wages, just close down your industry. That's the kind of stringent interpretation that the Supreme Court gave in the case of Raptor cars. But even much before that, how to frame the minimum wages, or how the government should calculate the minimum wages, is what we call as Dr. Ackroyd's formula. This is what was approved by the Supreme Court and what goes into fixation of minimum wages. So it says that a standard family is to consist of 3 consumption units. So basically the male or female, and then the spouse and the children taken together, it's taken to be as 3 families. And based on that, they have different parameters on what basis the minimum wages should be drawn. Then moving in Alfred case, the question came, if the government was to say that minimum wages shall consist of basic wages and dearness allowance, should it be paid only in the same format, or other allowances are to be taken, especially given house rent allowance is a component that is specifically defined in the term wages under the Minimum Wages Act. So the Supreme Court clarified the gross wages is what should be seen. As far as the gross wages is more than the prescribed minimum wages, it would be in order. A similar question came about even much later, very recently in the Supreme Court, and they have once again clarified that segregation of wage into different components is permissible, and any prohibition in this regard by the government is incorrect. In the Steel Authority's case, though they said that once prohibition is noted is issued, the contract labor system cannot continue and all those things, but they have clarified there, when it comes to minimum wages, the contract labor can still have a claim, even if the contract labor is prohibited for the period they were actually employed. For that period, the contract labor can have a claim against the principal employer. This is again where the government, following advisory board, had published minimum wages, revised rates of minimum wages. Then it went to make some changes, claiming that to be arithmetical and clerical mistake. The Supreme Court struck down, saying that once you have published the rates, there's no question of going back on it, especially when that is being fixed by an advisory board. The Code on Wages 2019 has also looked into the minimum wages. It's again going to the question of floor wages, which is something new. When it comes to the question of fixation of minimum wages, each state government is required to ensure that the minimum wage is above the floor wage, and it cannot fix below the floor wage. And the concept of scheduled employment has been eliminated. But the primary principle minimum wage concepts quite remain the same even under the Code on Wages 2019. In the Know Your Codes section this month, under the ICU do provide for fixed term employment, and even if a person works for 1 year, he is going to be entitled to gratuity. But when are these codes going to come is going to be the $1 million question. Well, this has been hitting the headlines from the last few days on how the BCCI has decided that women cricketers and men are treated on par when it comes to the pay for each match is concerned. Hope that similar things happen in other sports as well. One of the airlines has recently introduced a scheme by which, if for any reason air hostess or somebody who's into the flying gets pregnant, they would be looking at other ground jobs for these persons during the relevant period. So that this is something that's been hitting the airline industry for a very long period of terminating pregnant attendants because they will not be able to take the flight risk. So now they have come out with a scheme where they would be able to give ground jobs. This is one of the airlines that have thought about this. Moving on to the case laws, we are looking at one Supreme Court case law and one High Court case law. The Supreme Court case law is on where the employee was terminated and an approval petition was filed. In that approval petition, the tribunal held the inquiry to be bad and directed the management to adduce evidence. The management thereafter adduced evidence, and appreciating the evidence, the tribunal granted the approval. The workmen thereafter raised an industrial dispute. The Labour Court ordered for 50% back wages as compensation. The High Court also confirmed it, but Supreme Court reversed it and said, once the tribunal has appreciated the evidence and has granted approval, the question of Labour Court granting leave does not arise. Well, to be very candid, this judgment goes contrary to certain earlier judgments of the Supreme Court. It would need to be seen whether this legal principle laid down here is going to be followed by the Supreme Court subsequently, or it's going to take a reversal, because the right of a workman under Section 2 capital A to approach the Labour Court has consistently been upheld by Supreme Courts, whereas this judgment takes a deviation, and we need to wait and watch how this judgment gets to be interpreted and subsequently by the Supreme Court. This arises out of Punjab and Haryana High Court, where an employee was dismissed for holding strike, instigating co-workers. The Labour Court upheld the punishment, saying it's not shockingly disproportionate, and the High Court has also held that the punishment was right and said the dismissal cannot be interfered with. Moving to our posh segment, there was a complaint in a college, and under the POSH Act, the IC committee was having a chairperson who was from a group college, not from the same college. And the IC, in fact, went along with the inquiry and gave a finding that the complainant should be punished and it's a frivolous complaint. At this point of time, the complainant went to the High Court. The High Court struck down the inquiry report and said that the IC was not constituted properly, and IC should be constituted with somebody from the same college. When the college went on appeal, the division bench of Kerala High Court also confirmed the judgment and said that the constitution of the committee was not right, and directed reconstitution of the committee and for a fresh inquiry. So the answer for our question is that there should be an agreement for every audio-visual worker, and without which such an employment is prohibited. The last of our segment, the complaints calendar. Of course, we would be sharing this to all our participants. The PPT would be shared and you would have the benefit of it. Thank you. Thanks for joining us this month. We'll again meet on 26th.